Good morning, Your Honors. May I reserve 5 minutes for rebuttal?
Yes, ma'am.
May it please the court. My name is Megan Alexander and I represent Progressive. In this case, the trial court departed from the essential
Can I
requirements.
ask you a question?
Absolutely.
Where's the irreparable in this case? Because this is a cert proceeding that's jurisdictional. And basically, you have an in-camera inspection of this agreement that you all are here to try to protect. After the in-camera inspection, the circuit judge agrees that it should be released, made available, and it's released and made available pursuant to this agreement that you all basically authored, at least had a part in, to protect it from further disclosure. So it's really hard to see irreparable harm here, and if we can't get past that part of it, we shouldn't even be, I mean, this will be dismissed and won't even be denied.
Yes, Your Honor. Thank you. There is irreparable harm here, and actually, there was already a motion to dismiss that was filed by appellee that was denied. And the reason why there's irreparable harm is that this is a trade secret document. There is no dispute that the Safe Flight contract between Safe Flight and Progressive is trade secret. And in this case, the appellee's attorneys are ones that litigate regularly with hundreds of cases against Progressive and against other insurance companies. They have CRNs pending, and the information contained within that Safe Flight contract, whether or not it would be certainly be purposeful, I don't know that by any means, but that mental impression regarding what the terms and conditions of that Safe Flight contract, if it were improperly produced, is irreparable harm to Progressive. On top of that, that confidentiality agreement, and just to be clear, it seems
the test is whether it would be irreparable harm if it's disclosed. So I view it a little bit differently than perhaps Judge Morris does, which is why is this a departure? The judge looked at it, reviewed the pleadings in the case, reviewed the defenses in the case, reviewed whatever was before it, and made a determination that this goes to the heart of the issues that have been pleaded. And your client didn't, I don't know if they pursued a motion for summary judgment, but they didn't succeed if they did pursue it. So these are the issues that are in the case. So why is it a departure?
yes, Your Honor. It is definitely a departure from the essential requirements of law for 2 reasons. One, it is not relevant whatsoever to the proceedings.
Well, it doesn't seem to me to be as clear as you are arguing. You said it's absolutely clear. Well, how is that clear when we see what the issues are? Bad faith, essentially misconduct is alleged on the part of your client. Why doesn't a side agreement with Safe Flight, which is what we're talking about, why would that not be relevant to lead to the discovery of admissible evidence? That's a standard. It's a pretty low standard.
It is a low standard, but for 2 reasons. In this case, it is a departure from the essential requirements of law for this document to be produced. One, and I think very important, this is a trade secret document. And so what
Trade secret documents in and of themselves are not absolutely protected, are they?
no, not at all. Your Honor.
Okay, so let's set that aside. That doesn't win the case for you.
Sure, but there has to be a reasonable necessity for that document. And I think the case law in the second DCA specifically is clear that in order for that document to be produced, there has to be some sort of showing, there has to be some sort of finding. And the uncontroverted testimony in this case.
Wait a second. There's testimony that there's a contract between Safe Flight and Progressive. That's in the allegations of the complaint. Seems to me that the existence of that being able to get those reasonably calculated to lead to admissible. So here's the bottom line. Did Judge Polo apply the correct law?
She did not.
Yes or no?
She did not. No.
How? She applied the law with respect to trademark. She applied the rules of evidence concerning relevancy. She analyzed protected work product material, trade secret material, confidential material, correct?
She did an in-camera inspection.
I just want to know if you don't like the decision.
It's more than that, Your Honor. It absolutely is. And what happened in this case is that, like I said, there was uncontroverted testimony that this Safe Flight contract and the allegations that are in the complaint have nothing to do with what's actually being alleged.
Were those allegations stricken from the complaint?
Those were not stricken. Your
And the
Honor.
complaint still says that Progressive entered into a secret pricing agreement with Safe Flight for even discounted rates, and then it goes on as to how that impacts your client's evaluation of windshield bills for repair or replacement.
Right, Your Honor, and that's kind of the next point I can get into is this is this is an appraisal case. And I think that's very, very important because in this case,
May not say your client underpaid.
it did, but what Progressive's initial offer was has nothing to do with whether or not Progressive acted in bad faith in the handling of the
No, it
claim.
doesn't, but the allegations are there that it's in bad faith.
And I think that what the.
So you're asking us to ignore the allegations of the complaint, because isn't that what discovery is for? To let the parties flesh out evidence that relates to issues that have been pleaded.
I think it does in a general sense, but there is a higher burden and a higher standard when there's a trade secret document that is being asked for. And specifically in the case, and let me just make sure I cite it correctly, Your Honors, the Gulf Coast Fine versus Walker case. The court, second DCA specifically said in that case, the court would go into a fact-specific analysis and any disclosure must be supported by findings. The trial court in this case completely ignored the court representative testimony, which was the only evidence that was actually before the trial court.
Sam's versus St. John's, fifth DCA case, 1998, kind of says it as good as it can be said when it comes to cert. The appellate court should only exercise its discretion to grant the extraordinary writ of cert in the extremely rare case where it is necessary to correct an inherent illegality or irregularity, an abuse of judicial power, an act of judicial tyranny perpetrated with disregard of the procedural requirements resulting in a gross miscarriage of justice. You're not even close to that here.
And, respectfully, Your Honor, I would have to disagree because I don't think.
Gross miscarriage of justice.
I think it is because of the fact that this is an appraisal case. This is a case in which what that initial offer is, which is the only potential.
But your policy says that you will determine the rates and the payment based on the competitive rates in that market. Having a contract with SafeLight is the antithesis of that, because that means you got a contract with them. You're not shopping around with anybody.
Your Honor.
How is that not relevant? Put yourself in their position and tell them. How is it not relevant at this point when the allegations of the complaint are still taken as true?
It's not relevant at this point, again, because it is a trade secret document and because of the fact, I think that this court has kind of already addressed the relevancy as in an appraisal type situation as to whether or not that type of document would be relevant. And in this case, Hillsborough Recovery, which was recently decided this past year, the court specifically said, furthermore, to conclude that Progressive's notice of a disagreement between it and Clear Vision is indicative of bad faith is fully without support in the record. Progressive investigated the claim, acknowledged coverage, reviewed Clear Vision's invoice, and tendered an offer to settle pursuant to its contractual duties. The record clearly demonstrates a disagreement between Clear Vision and Progressive over the value of the claim.
Did it?
I don't believe it was a breach of contract case, so no, I don't believe so.
So you're in a different ballpark.
But I think that the next line is what's the most important here. And it says, once appraisal was properly invoked, this dispute was ripe for appraisal, a process wherein any errors in valuation of the loss which the trial court mistook for bad faith would be resolved by the selected appraisers. And that's exactly what's happening in this case.
Anytime appraisal takes place, there can never be a bad faith claim in a windshield case is what you're arguing.
It follows the same fact pattern as this case was a recovery.
Steve pointed out, that case didn't involve what we know exists here, a side agreement with SafeLight, which the appellees and respondents argue allowed or caused your client to artificially deflate the amount it would offer.
And Your Honors, I think that is the only thing under pursuant to the terms of the policy that Progressive had to do is recognize that there was a dispute, which is exactly what Progressive did. So that initial offer, they could have offered nothing. They could have offered $1. It doesn't matter what that initial offer was.
Which means
And that's
that
why
what your position seems to be is in these types of cases, if no offer is made, there can never be bad faith.
if there is, the invoice is received and there is a recognition that there's a dispute and an invocation that appraisal clause, yes, I would say there would never be bad faith in those circumstances.
Well, I understand your argument.
Thank you, Your Honor. I think that what else is important in this case as well is that this trial court, once the hearing occurred, ordered the production of the SafeLight contract within 2 days of the hearing. And that order was endorsed, which was completely drafted by Lords of Shelton's counsel. It was a 7-page order within 52 minutes after the proposed order was submitted by appellee and was completely unedited or unrevised.
Are you saying the judge didn't read it?
I'm not saying the judge didn't read it, but I think
Okay, because let's go through it, because paragraph 2 does include what the court said at the hearing, according to appendix 441 and appendix 440. Paragraph 3 includes what the court said in the oral findings in appendix 448. Paragraph 4 includes what the court said in appendix 48 about the reason the need for information, the reasonable necessity for the information, the qualified with the trade secret, plus the proposed order you submitted agreed with the bait stamp numbers that the court agreed with trade secrets. So how can we tell that this particular judge just bought what they said and sided with the plaintiff?
I think that the issue here is that there was no recognition whatsoever to the corporate representative's testimony, which again was the only evidence that was actually before the court, and which specifically stated that this, in that corporate representative's testimony, that Safelite does not do any adjusting of the claim, which is the first allegation. It's uncontroverted. There's nothing else in the record whatsoever to controvert that specific testimony. So
So you're saying in court, when somebody testifies and only one person testifies, notwithstanding what party it is, they have to be ruled.
I think the court has discretion to decide what it believes, but I do think that it is significant that there was no evidence whatsoever in the record that actually took the allegations in the complaint that the plaintiff is making and why they're saying that this document is relevant.
Order didn't mention your expert's testimony.
I think
Why
it's,
not? You're already here.
Your Honor, I think that it perhaps should have, but
If
it's,
it's that
I think
important,
it's,
why don't you do it below?
it could have, but I think that the point of it was that the motion should be denied, which was really
The
the
testimony
basis.
acknowledged that there was an agreement with Safelite, correct?
The testimony acknowledged there was an agreement with Safelite. Yes, sir. Yeah, it definitely did.
And the court took that into account, that there was a known agreement with Safelite that is the basis of at least some of the allegations of the complaint.
That's what the court said.
So what in the testimony of your witness should the court have relied upon to reject the plaintiff's discovery request?
The two allegations in the complaint were, one, that Safelite essentially adjusted the claims, and number two, that there was a secret contract that basically Progressive was undervaluing the claims. The testimony of the corporate representative was exactly to the contrary. Number one, Safelite had no involvement.
So you're appealing the denial of summary judgment on those issues to get rid of those allegations?
We haven't motion for summary
The
judgment
answer
yet.
is no. So we still have the allegations in the complaint. We have some evidence that supports your client's position, some evidence that doesn't support your client's position. And the court said, I'm inferring, the court said in his or her mind. Well, let me look at the document and see if it may be relevant to the allegations in camera. Isn't that what the court's supposed to do?
That is what the court's supposed
And
to
even
do.
if there is a lot of evidence supporting your client's position, until those allegations in the complaint are disposed of, isn't the court supposed to look at an agreement like this and say, well, it's relevant to what they've pleaded. I understand you've got some great testimony that may undermine that, but they've made the allegations and their allegations in the complaint.
I think the reason that it's a higher standard is because it's a trade secret document. I think that an appellee has to show more than just the allegations in the complaint in order to have a trade secret document. There has to
They
be.
also showed the conduct of an offer, which ultimately was low, according to the appraisal process. I understand that in and of itself doesn't prove bad faith, but you've got these allegations, you have an acknowledgement of an agreement with Safelite. You have other allegations that are relevant to the question of bad faith conduct. And then the court looks at this agreement and says, yeah, this is relevant.
And Your Honor, I still think that there needs to be more than that. I don't think that that is enough for the protection of a trade secret document, especially in the fact circumstances of this case and the fact that there was this appraisal that occurred,
Just so you know, you were at 15 minutes, but it's your time. Use it any way you want.
Thank you, Your Honor. The only other thing that I want to bring up is cases that were cited by appellee in terms of Levinas. I think that there is that was heavily relied on by the appellee in their brief. And that case, GEICO does not have an appraisal provision in its policy, which I think is a very important distinction based on the argument that I made regarding Hillsborough recovery case. And I will save the rest for the rebuttal. Thank you.
You'll have 4.5 when you come back.
Good morning, the court. I'm David Calavia. I'm here today with Anthony Prieto, who represent Lloyd's of Shelton Auto Glass. This petition has no merit and should be either denied or dismissed.
So the motion to dismiss, which was disposed of by a motions panel of this court, asserted that the jurisdictional threshold hasn't been met. And you haven't really re-argued that. You've alluded to it in your briefing, but this is your traditional cat out of the bag type discovery. Ultimately, isn't the question, did the judge get it wrong? Is it a departure?
Okay, so a couple of steps in that question.
First,
First,
you figure out why it should be dismissed when this
Should be
is clear cat out of the bag type discovery.
well, the cat's still in the bag. The cat,
But that's
The
not
cat's
true.
by-
The cat's not in the bag, Mr. Callaby. If the court has ordered it to be disclosed, and the only reason it hasn't been disclosed is there's a certiorari proceeding pending.
so
So if we were to say the court got it right, have we got the bag right?
my position is the cat is on a tight leash inside that bag, and we can peek into the bag every once in a while, and then we gotta keep that cat right in the bag. The standard is when cat out of the bag discovery can be used to harm another party or person outside the context of litigation. That's what the Florida Supreme Court says in Allstate versus Langston, not whether they're prejudiced in this lawsuit. Of course, it's gonna affect them in this lawsuit because we're their adversary. The question is, how are we gonna destroy their business by having this contract where we're officers of the court told that we're not allowed to even share it with our client, and we're have very highly restrictive measures imposed upon us that were drafted by Progressive, by the way, and they found that it was perfectly fine. They didn't tell the judge, oh no, we need more restrictions. The cat's out of the bag. They never said that. They never presented that. I respect Judge Silverman. I do disagree that there is any irreparable harm in the situation where there's a protective order or a adequate protective order or an adequate confidentiality agreement in place. How can they possibly suffer any harm, much less irreparable harm? That's defined as under Allstate versus Langston. I think this court denies motion to dismiss as it did in this case. I think that's without prejudice to the panel being able to take that up again in an oral argument.
Well,
I think
it appears that Progressive agreed to the confidentiality agreement in anticipation that we might deny this. So that's probably the practice, but that doesn't eliminate the issue of capital back. Well, so there are numbers of confidentiality that is no reason that whether this is, they prove the harm. So it's a trade secret. I think you agree that part of it's a trade secret. You disclose the trade secret.
So we agreed that this is a trade secret. We stipulated that without ever looking at the document, without seeing it. I have a little issue with that with my trial counsel, but we did stipulation. There's no evidence that it's trade secret other than our stipulation. So let me just say that.
And the purpose of release of the document and the purpose for discovery is to be able to use that document and information contained in it to establish bad faith.
Absolutely.
So that document will of necessity, if it is as relevant as your client thinks it is, will of necessity become public, at least in part, because it will be used to show a side deal with Safelite that results in Progressive intentionally undervaluing the claims, and that's the heart of your lawsuit, right?
Right, but it'll be under seal, and it'll never be public.
The jury would hear about
I guess so.
it. And that becomes public record unless this is going to be a sequestered jury and everything about this case is confidential, which we know sealing doesn't typically take place that way, right?
I don't know that, but I'll take your word for it.
Now, once there's a trial, we don't need to argue that.
Right. You know what, I'm not gonna convince you that there's no irreparable harm here, so let me just turn to an issue that I think I can convince you about. Council said over and over that there's absolutely no evidence that Safelite is the one adjusting this claim, and therefore that's why it's irrelevant. There's one allegation in our complaint that says that the contract delegates to Safelite adjusting claims, but the lion's share of our complaint says that, look, there is a side deal between Progressive and Safelite. It agrees on lowball price parameters between Safelite and Progressive. And then what Progressive has done is they've used that lowball pricing parameters and applied it to everybody else who's not a party to that contract. We took the corporate representative's deposition, and I know you're understanding the appendix, so I'm going to direct you to pages 572 through 576. I'm going to read some of the testimony that counsel just said is not in there. Question at page 572, line 18. Does Progressive, in determining reasonable and necessary pricing, take into account the pricing which we discussed in the Safelite contracts? Is that one of the factors it takes into account in determining a reasonable and necessary pricing for the replacement of the windshield? Paraphrase it. Answer. So I will say the Progressive glass claims data is inclusive of the Safelite auto glass. All right. So what they're saying is the data we use to set the prices for Lloyd's includes the Safelite prices. Then the witness goes on to say Progressive determines the pricing. Safelite has no other involvement in regard to determining what are reasonable and necessary rates are. Okay, so they're saying Safelite's not the one who decides it. Progressive's the one who decides it. Fine, Progressive is deciding we're going to use the lowball prices that we've agreed upon with Safelite. We're going to use that and impose that on Lloyd's. Let me take you to the next question. This is on line 8 of page 574 of the appendix. Question: how does your present reasonable and necessary pricing determination on glass claims compare with the contractual rate you've agreed to pay with Safelite Auto Glass? Objection. That's confidential. So we ask, is there a relationship between the two prices, the prices you pay to Safelite and the price you pay to us? Oh, we're not going to let you know that. So clearly it's relevant. It's alleged in the complaint. The judge found it relevant. The judge went through all the procedures that the judge required to under Your Honor's case and Bright House versus Cassidy and all the other cases. There's 3 steps that they have to go through. In-camera inspection of the contract, which we haven't seen. The judge looked at that contract and says, there is evidence in here that's relevant to the allegations in the complaint. This request for production is reasonably calculated to lead to the discovery of admissible evidence. The second step, if the document includes the trade secret, the court must determine if the party requesting the information has shown a reasonable necessity for the information. The judge made that finding. Third, if the disclosure is required, the judge must make findings to support that determination. Okay, the judge made lots of findings. She did it orally on the record at pages 440 through 444 of the appendix, excuse me. Paragraph 4 of the order and paragraph 7 of the order. I can go through the findings, but Your Honors are obviously familiar with it. So she complied with everything Bright House said. Then there's a 4th step, and it's not in Bright House because in that case there were customer lists that were required to be produced without any camera inspection. And so this court gave those first 3 procedures that had to be followed. There's a 4th step in section 90.506. It says the court shall take protective measures that the interest of the holder of the privilege, the interest of the parties, and the furtherance of the justice require. So The protective measures are the ones that Progressive themselves proposed. So how could she be faulted for adopting those protective measures? She can't. It's certainly not a tyrannical judicial tyranny that results in a gross miscarriage of justice. There's no error in this case, certainly not a departure from the essential requirements of law. I don't know how much more I need to go through this outline there prepared, but if your honors have any other questions, I'm happy to answer. Otherwise, I'll just yield my time and ask you to at least deny, if not dismiss this petition. Thank you.
Thank you. We have 4.5 minutes.
I just want to point out the testimony that Appellee's counsel just cited to. They didn't read the last line of that actual statement, which I think is important. The last line actually says,
Which page, which one?
this is on 412 to 418 of the appendix, at I believe it's 107 to 108, 18 through 4. And specifically, the answer was, excuse me, the question. The answer was, so I will say that the Progressive glass claims data is inclusive of Safelite auto glass. Safelite Progressive determines the pricing. Safelite has no other involvement. They don't have an involvement in regard to determining what our reasonable and necessary rates are. And it was specifically said by the corporate representative.
There's a low ball agreement with Safelite, low balls converters. But if there's a discounted pricing with Safelite, and your client says, or the witness says that is part of the evaluation that your client does. So potentially that causes your client to artificially deflate the amount it believes is reasonable. I mean, isn't that a way to look at this?
But it doesn't. The Safelite contract doesn't do that.
How do we know that? I mean, the court reviewed it in camera and apparently keeps contracts relevant to that issue.
Your Honor.
Are we to take your word for it?
No, but that is, I think, the purpose of the petition for cert, and to bring this to the second DCA at this point is to basically bring before your honors whether or not there was a reasonable necessity for the production of this cat out of bag discovery, because based on the only evidence that was presented to the trial court, Safelite doesn't have any involvement whatsoever in determining what Progressive's reasonable and necessary rates are. It was specifically said by the corporate representative, and there has been 3 years of discovery. Progressive has produced the entirety of its claim file. There has been multiple depositions, and still to date, there is zero evidence other than these unsupported allegations in the complaint to support that this document, a secret document, should be produced. And it wasn't just Appellee who agreed that this was trade secret. The court also found that this was trade secret. So I think that that's an important point to make.
But you're arguing that you have to prove bad faith before you're entitled to something like this. That's not true. That's what discovery is all about.
I don't think you have to prove bad faith, but I think that you have
You're
to
sitting there
show-
telling us it's not a bad faith case based on your corporate rep's testimony. Well, that's irrelevant right now for discovery purposes. That's why we do discovery, to determine what's admissible and what's not, and then you take it to the court for a summary judgment.
I think that generally I would agree with that, except there are bounds for discovery in terms of relevance and privilege. And this is one of those circumstances where there's a privilege, a trade secret privilege that is
But the
applicable.
corporate rep just said that this Safelite is involved some way, somehow. You know, they had an agreement with them. And their agreement with them affects the pricing.
And I don't affect the pricing. I don't think that was.
Well,
what the
it
testimony
somehow
was.
affects the pricing. That's what he just said here on page 574, from you in there. They had that contract before. I mean, there's a question. About, do they do something before the contract with Safelite? And their laptops just crapped on. But anyway, but the point I'm trying to make is you're arguing the merits of the bad faith to us. When at this stage, this is discovery. We're not taking sides here, we're just simply saying their allegations are that this side agreement with Safelite affects their pricing to the point of bad faith. There's testimony. Is it regionally calculated to lead to municipal evidence? Yes. Okay, so if it's trade secret, then I'm hearing that the judge did what she was supposed to do with respect to analyzing trade secret documents. And to that effect, your proposed order agreed to the stamped pages about trade secret. You didn't object to disclosing anything else.
And you're out of time. But go ahead and answer his question.
And I would disagree that that's what the testimony supports. I think the testimony is very clear that Progressive didn't have involvement. But I do hear what Your Honor is saying. I think that the standard is different when there's a trade secret document. I don't believe there was a showing that would enable a reasonable necessity to be found. And I think that this January 6, 2023 order should be reversed, and respectfully would request that.
Thank you both. The words were great and your arguments are very helpful. It's an interesting case. Thank you, Your Honors.
Thank you, Your Honor.
We're adjourned. All rise.